think it all be under on that. Not taking a vote, but I just kind of.
I can't see why the county would allow us to build it and then just turn it back over to them to run. I see your point of building our own. Make a lot of sense, especially since we're looking at potential LCI overlays on Peachtree there. We have all talked about incorporating them in the past.
Yeah.
So this would blend in perfectly with plans down the road. I fear, though, from what I've heard, that this has been moving along a lot faster than we realized, and they're looking to take action and spend that money on that library sooner than later. So maybe clarification might be good.
We'll add that to our list for tomorrow.
Thank you.
If we hit an impasse, then yeah, but
I'm talking about on this issue.
Yeah, I'd like to find out if it's possible. I mean, that's really, right now I'm trying to understand if it's possible, if there is that potential, and you know, if it does take a future action by mayor and council, then I think we can do that. But what I'd like to find out is it possible for us to pursue that course?
We'll broach that tomorrow,
Okay.
and we'll find out what their idea of the possibilities are.
Okay.
For all of us up here, I've seen, we need to speak up so that they can hear it, or you'll need to, if you're having a hard time hearing, come forward if you can. But we'll try and speak up a little louder.
All right. Next, Nick report, please.
I'm going to defer to
Jed.
Jed.
Thank you, Mayor and Council. Thank you also, City Attorney Mr. Riley, for allowing me to finish the project I started as a member of the Governor's Commission.
You're not done yet.
Well, I hope so. This topic is the municipal court lease, and for those of you who may be new to this, the municipal court lease required unique parking arrangements because you have a big collection of people coming for day court, and it was a use that required us to do two things: find a commercial space that had enough parking to accommodate this influx for when court's in session, and it had to be in the city, Brookhaven, city limits. So we located a space in Corporate Square. It's in Building 2, Suite 125, and just finished completing negotiations over the lease. The lease came out consistent with the proposal that you all approved in December at one of your first meetings. We did have to tighten up some insurance requirements. Those came out in our favor, so we did not have to buy any extra insurance to satisfy the landlord. I'm pleased that Chuck and his team are ready to go out and hit the ground running on getting the space built out. It requires paint, carpet, and some wiring, so I think it's important to get this lease approved so that Mayor and Council can execute.
Yes. Who handles that portion of it, building, painting, and carpeting, and all that?
Well, I'll defer to Chuck, but it's up to the city to make those arrangements under the watchful eye of the landlord. The landlord is not contributing funds.
What department would that come up? Is there a building? I mean, there's something.
Well, Chuck's group is designing it, and they have engineers and staff, so they've already been doing drawings and things.
So, like, how do we bid out that work to
Collars, who I'm meeting tomorrow with people that run all the building, and I'm going to discuss that whole issue with them concerning how, obviously, it's not in the lease, so somebody has to come up with money from the city. I don't know how much that's going to be. It's minimal, but there's a lot of stuff going around this, and I'll know a lot more about when I meet the construction.
I'm sure there's some Brookhaven contractors who'd love to bid on that small little job there.
It's a small job. It's 3,800 square feet, and I can't say how much the wiring would cost, but the estimates I've heard for the sheetrock paint and wallpaper are in the $4 to $5 a square foot range. So we're talking about less than $20,000.
Basically, we're just putting a wall up, putting a door in, taking a door out, putting a window in, and taking a little wall out, and putting a little bit of wiring in. I'm sure there's going to be some carpeting in it.
Yeah, only
unless we don't want to go that expensive.
So, you know, I've reviewed the lease. Mr. Riley's office reviewed it. It's ready to execute. And upon approval, y'all can do that. And if you get it to JD in executed form, he can deliver it as needed.
All right.
Thank you very much.
Thank you. All right, status of contract awards.
Yes, Mr. Mayor, before I get to that point, I failed to introduce your management team.
Oh, did you?
Yes, and that would be Bill Riley, your city attorney, and J.D. Clockadell, who is the interim deputy city manager, and of course myself. And we're looking forward to later in the agenda, the appointment of the city clerk, so we can add her to the management team that is making sure that your policies are implemented and that staff is managing their workload and getting things done. So,
All right.
getting back to the contract awards, we have all of them in good shape. There's one that we're still tweaking, but the majority of them will be on your desk tomorrow. All task orders have been negotiated and accepted. The city attorney's office has been working on the contract, so they're all ready to attach the contract back to the task order, and will be available tomorrow for you to sign, Mr. Mayor.
Thank you. All right. Yeah, will we get those to council too
Yes, absolutely.
before? Why don't you give them to council before you send them to me, so I'll run up and sign them real quick before they have a chance to. Okay. All right. Status of city manager search.
Yes, Mr. Slavin is here, who is the search firm that mayor and council have engaged. He's working with our HR director on staff, Rick Stone, but he is here to give you an update on where we are.
Mayor and Council, I'm Bob Slavin. I'm going to get right into it. If you want me to talk a little bit about me, I will, or I'll answer questions. But we got the job description last week. We have drafted a announcement and a recruitment program that's in my office now, ready for me to. It's being approved today. I think it's ready for me in final form. It'll be published tomorrow. The publications are fairly typical ones used for to recruit city managers: International City County Management Association, the Georgia Municipal League, Florida Municipal League of Cities, some other city leagues, particularly municipal leagues, particularly in the southeast. There are a couple of national publications we'd like also to place it in order to circulate the word far and wide, if you will. We have begun the networking process. I've actually made calls, talked to people about the job, have 2 or 3 resumes in. And I think the city has also received 2 or 3. Those are being sent to me. We'll acknowledge them all and keep and track everybody who applies. We're going to advertise. The advertising will ask people to apply immediately, so that we're not waiting for some distant date to be achieved, and so that we can move fast. Once we have quality people, we'll bring them to your attention right away, with the thought in mind that we don't have to wait for some arbitrary date. Process should go well. The response I've gotten so far from people I've talked to about this is positive. It's an exciting opportunity for people, and I should have started my conversation with you tonight by telling you how delighted I am to be involved in this. And I think that the response I've gotten so far is indicative of the quality of the people we're going to get, and it's good.
So you're saying the job is going to be posted tomorrow?
It will be posted in the professional journals tomorrow, and on websites.
Okay. We'll do that tonight? Is it possible?
It wouldn't do any good tonight.
I know
I'm
what
just
you're
saying.
The time is extremely important in this, and I want to impress upon you how important it is that we move quickly on this, because we've got several things, kind of a domino effect, that we have to get our city manager in place. We love Marie, but we want to prepare the job as soon as possible.
Well, she's been very good and very accommodating, and we haven't sat on the information that we've had for at all. I think we got it Thursday night, and I was out of town on Friday, but Saturday I was working on it. So we're on.
What is your time estimate for how long do you think it will take to get some people we can start interviewing?
Well, I'd like to say within a month at the very latest, before we have quality people you can talk to. The process usually takes 90 days. But by doing it without putting a final filing date, we ought to be able to do it faster. And I'll keep you informed.
Is there any other language you can use on the posting to let people know we want to wrap this process up without hamstring us?
I think language to the effect that this is a new position and a new community. They're anxious to move rapidly, apply immediately, and it'll be open to fit. I think that'll do it.
Is that what it says?
That's what I drafted, words to that effect.
Any other comments or questions from anybody else?
So what do you think is the total time frame before we might?
I would hope you'd be interviewing within a month, and it's really kind of hard to forecast because you need quality, you don't need quantity, and but I think we're going to get a quality group of candidates within that period of time, and you should be able to be interviewing. There is some process that we need to go through, and it's basically due diligence. We need to make sure these folks are honest and have done what they said they were going to do, and that their expectations are meet your expectations, so that and that there's nothing in their background that's going to be surprising or keep them above. So we need to do that. So that takes some time. But the way we're planning on moving this process along, we won't be waiting for a group of candidates. So as we get good people in, we'll begin that vetting process. I'll stay in touch with Rick so that you folks are aware of what we're doing, so that we're partnering with this, and it's not my company telling you what to do. It's you working with us, so that we're working together on this. But I think by announcing it the way I am suggesting, telling folks we're going to move it along, we have no obligation to people who might apply next week if we choose to go this week.
And if you added the resumes that have come in through the website or previous to your involvement into the mix, or how does that work?
They will. I don't have them yet. I talked to Rick today. He's sending them to me now.
Okay.
But they will become part of it.
Right.
It's just one batch. So we put them all together, we track them, we acknowledge them, we track them, we keep people informed, and ultimately we let everybody know what happened.
Right.
Are you publishing a salary range?
No, I'm going to leave it open. It's open and competitive. I understand that there have been some numbers suggested, and they should be fine. But if we put that number out there, you're never going to pay any less. If the best person interested in the job may need a little bit more than that, you'll never talk to that person. So I'd rather leave it open and competitive.
Okay.
Once you get a candidate, how long does it take you to vet?
We can do it in some of the response to that question involves things we can't control. We use Wackenhut, whatever they call themselves now, and Equifax, and some outside agencies to do the vetting. And it depends really not on the court systems that they need to access. Some of those court systems will turn around the request real quickly. Some of them take a week or so. It doesn't take long, but I can tell you that we can do it in a day is not right. Then we need to do the referencing, and we also do a lot of Googling. And one of the things in our contract, and we'll want to talk about, is that our process involves site visits of candidates. Now, when we do those, it's kind of up to you. I don't want to hold a process up to because we're trying to work out an arrangement to go someplace to meet somebody. But we can do everything other than that. I sense, not just from you folks, but from your staff, that you want this thing to move. So we're going to make it move, but we're going to do it in a quality way.
Exactly.
Anything else? Jim?
No, okay, thanks.
Thank you, folks.
Thank you. JD?
Yes. So we have notified the facilities that we would like to have for a permanent location. And the contact is out of town until Friday, but I will be contacting Dr. Hammer tomorrow to see if we can lock down St. Martin's. And keep in mind that we discussed in the last council meeting having some other options in case we want to have some southern part of the city, so it's convenient for others, the northern part of the city. So we have multiple options. Councilman Gebbia has given me basic contact with a facility in your area.
I haven't received contact.
Yeah, response yet. No response yet, but you may contact. I've actually talked to that same facility, which is near down there. So we will have something by the end of the week in terms of permanent facilities for city council.
All right. Okay. Secretary of Business. Now, this new business.
Mayor and Council, under new business, the first item is consideration and approval of a one-read ordinance to adopt and approve sexually oriented business ordinance for the Code of Ordinances for the City of Brookhaven. At this time, I'd like to ask that Mr. Berthold come forward and to make a presentation for the council, so they will have a further understanding of what the reasoning is behind this ordinance.
Thank you, Mayor, members of the council, and interested citizens. We're here tonight to talk about the adult entertainment ordinance. We've talked about it before, so I'm not going to repeat everything you've heard before, but I do want to sort of give the lay of the land, the status quo, respond to some of the comments that were made by my learned opposing counsel here, Mr. Valines, and then make a short presentation that lays the record for the ordinances before you tonight. The status quo is that the City of Brookhaven has adopted a set of ordinances that were in place in DeKalb County, and they did so on December 17th. Those ordinances were originally put into place after study, looking at crime reports, considering negative secondary effects that were documented in DeKalb County by their liquor commission at meetings, and they were modeled after laws that back at that point in time, many years ago, had been upheld by the courts. So that law that is currently on the books, that is the status quo legal regime in the City of Brookhaven, bans alcohol on the premises of adult entertainment establishments, prohibits dancer patron touching, it requires licenses. It does substantively a lot of the same things that the ordinance that is before you tonight does. Substantively, it's on the same level. However, there are a number of constitutional defects in that ordinance that would limit its ability to help the city in any situation should they be sued on it, should a new business come to town, or any type of enforcement action that would take place under that ordinance. I previously laid out the memo to Mr. O'Reilly, just a handful, several pages of the constitutional defects, including unconstitutional overbreadth, vagueness, prior restraint problems in the licensing procedures, the zone out that's imposed by the location restrictions, and we talked at length at previous meetings about the practical implications of this defective scheme that's on the books right now. Someone comes in on Buford Highway, Peachtree Road, they essentially are going to win a lawsuit if the ordinance is enforced against them. They're going to be grandfathered, potentially in a very bad location. You've heard tonight that you shouldn't worry about that. You shouldn't adopt insurance in the form of good ordinances. You should proceed with the broken scheme and just wait for something to be the wolf at the door. However, that's when you'll get the public outcries, when the citizens are concerned about what was not done when the city at its inception had the opportunity to address and to adopt ordinances like those that A, have been upheld by the courts, B, are like the one that is currently on the books in the City of Brookhaven by virtue of adopting the DeKalb County scheme, and C, are like all the other cities on the north side of Atlanta that have been adopted in the last 5 years to protect their citizens from the negative secondary effects. The second comment that you heard was about the settlement agreement, and you heard a claim that it's binding on this body. If that were true, then it wouldn't matter what you adopted tonight by virtue of ordinance, because the settlement agreement would protect that entity from the applicability of the ordinance that's under consideration. But because I think we all know that that doesn't pass the smell test, that the city does need to have good ordinances because they would be binding on any sexually oriented business in the city. That's pursuant to the Revised Code of Georgia, Section 36-30-3A, that plainly states that one council can't bind a future council. All the more than a county government cannot bind a city government.
So I guess 36-30-3A.
That's right.
Read that again, please.
Yeah, that's the statute that says that one council cannot bind a future council. And the courts have applied that equally to cities and to counties. And in this case, it's sort of what lawyers call an a fortiori case, or a stronger case, because you're not a succeeding council from a prior Brookhaven City Council. You're a new governmental entity and a new sort of sovereign political subdivision of the state of Georgia, all the more that you wouldn't be bound by something that the county did.
And forgive me, if if you have a site on that code section at all, or we can get it to us later.
Yes, it's 36.
I mean, a case site.
Oh,
Where you
sure.
send it, well, that's available.
Sure, sure. And I have provided a memorandum to the city attorney. He can provide that to you as well. But there's a number of cases, Georgia courts have consistently applied that. There are some very limited exceptions that don't apply here, like when the government, you know, if you enter into a proprietary function to do wastewater management services and it's a revenue generator. So, but basically the courts are consistent in applying that statute to make sure that this legislative body, the city council, is not limited in matters of legislation and municipal government. And so, so if that were really a true concern, then it wouldn't matter what ordinance you adopted, and Mr. Blinds really wouldn't be.
Why is this language in, I mean, I know sometimes you put, lawyers put things in agreements to maybe get somebody like to stand on when they might have litigation, but why would that be in here if there's no legal grounds for it? Why would the county have a consent agreement that has language in it that is, in your terms, you know, clearly unenforceable?
Well, and I think in the statute's terms, but I think just to make somebody feel good, to make somebody feel like they were getting something that they thought they were getting, and that actually happens quite a bit in contract negotiations, where you give up a contract term, but you either know that contract term down the road would not be enforceable against you, or you know that the person that's on the other side of the negotiating table thinks that that contract term is valuable to them.
Let me ask this, do we know which party drafted the consent agreement? Was it the plaintiff or the defendant?
It was, well, it sort of doesn't matter because both of them sign it, and therefore it becomes an agreement when both parties assent to the contract.
Yeah, but in Georgia, you know, the
Right.
contract, ambiguities are construed against the drafter.
No, we don't know. We know the DeKalb County's attorney signed it on behalf of DeKalb County, and the strip club signed it on behalf of the strip club. But that's right. It's not like a contract of adhesion, like an insurance contract, though. It's a little bit different when you have parties that are represented by attorneys on both sides, and they both participate actively in the negotiation and drafting process. Yeah. And so, just as there's been new sexually oriented businesses in the last 5 years that have opened up in Floyd County, in Bartow County, in Johns Creek, those people, those cities didn't wait until a wolf was at the door. They adopted ordinances to deal with the problem up front. And so the hear no evil, see no evil policy is not a prudent choice for citizens, because that is what could lead to a new establishment being grandfathered at a very terrible location. So now we'll move into the presentation, and some of this information you have heard before. If we go to the first slide, the key case in this, as we talked about, is City of Renton versus Playtime Theaters. Simply said, reduced to its bare minimum, is that you don't have to do your own study. You can rely on this 3,000-page record that has been compiled and looked at on numerous occasions over the past month. You can rely on the studies, the police reports, the expert affidavits that are in the record, as long as it's reasonably believed to be relevant. And then if we go to the next slide, it explains that there are a wide variety of adverse secondary effects that have been documented time and time again. The 11th Circuit Court of Appeals has documented not only negative impacts on surrounding properties, but personal and property crimes. There's always a public safety risk component that goes along with those. Of course, in public indecency and sexual crimes have been documented around Atlanta, in strip clubs, adult bookstores, across the metro area on innumerable occasions. Also, illicit drug use and trafficking. That was documented most recently in Sandy Springs just last year, where several dancers and people involved in the establishment were arrested on prostitution and cocaine charges. And then the litter and aesthetic impacts that the citizens in Sandy Springs and other establishments have documented. On the next slide, we talk about the sources. There's a wide variety of secondary effect sources in that voluminous record that you've been providing, that we talked about on prior occasions. And they include land use reports, but they also include judicial opinions where the courts have repeatedly documented these types of effects, as well as expert reports. And we'll turn to that next. On the next slide, we look at some of the detail in the legislative record. There's 44 categories of documents would be the best way to say it. The Bates statement stops at page 2840, but there's more pages than that. They include numerous examples of each types of the secondary effects that we talked about in these slides. And they're from cities large and small. They go back to Los Angeles in 1977, but they're as recent as the 2012 study. And the U.S. Supreme Court said in 2002, in the last decade, that Los Angeles could rely on that study. There's actually a lot of old studies that in criminology, just in the science of criminology, one study from the 1700s in Paris, France, that is one of the most widely cited criminology studies. So don't get...
Had strip clubs back then?
Well, they had different... if you've seen Les Mis, they at least had bawdy houses.
Yeah.
And so the jack roller, you'll see examples of that in the old literature that is the foundation of modern criminology.
Just to clarify the record, you're not referring to Bates as me. Right?
No,
That's
not. Bates did not go through and stamp these. He did not actually do the original research to compile these either. But you've got a crime and delinquency article that's very recent, November 30th, 2012, for one of our other clients, Louisville, that documented much higher crime in and around sexually related businesses. And it includes affidavits from Atlanta area businesses, including the Pink Pony South in Forest Park, the Crazy Horse Saloon in Forest Park, as well as adult cabarets in Sandy Springs. And Scott, if you can go to the next one, thank you. I'm not going to go through all the details. The purpose is not to be salacious. The purpose is to establish that these are well-settled facts. These are the types of negative secondary effects that are documented locally at the Pink Pony South and other establishments are not new. They're not unique to Atlanta. They're not unique to Chattanooga. They're what cities have found and law enforcement have found time and time again in these establishments. If you go to the next slide. Some of the testimony in Sandy Springs, though, is very on point, talking about paid sexual contact, participation in drug transactions by dancers, illicit sexual activities in the back rooms. And that's why this ordinance actually has provisions that talk about the interior configuration of the establishment, the background checks that are on dancers. You want to make sure that people who have been convicted of prostitution aren't the people that are providing the erotic services on the premises. And there's basically a well-thought-out roadmap for drafting these ordinances that's up to date with current case law, and that's what the ordinance before you tonight does. On the next slide, we see some of the specific sort of criminology analysis that's very recent. And this one is a Louisville study that talks about empirical crime within 1,000 feet, saying that basically in the middle of the paragraph, sexually oriented businesses are associated with increased rates of crime. All types of crime, violent property, public order, are more common, and at the property and close to the location of sexually oriented businesses. As you move away from that point source, the crime rates decrease, but they still remain influenced by the sexual oriented business for very significant distances, more than city block. And then the next slide, what we've done is to preempt sort of some of the challenges that you're likely to see in these pieces of litigation. You talk about what our rationale is, what it is not. It's not moral disapproval of particular content of speech, or we don't like magazines or certain sex scenes. This ordinance doesn't regulate what people can see as far as the types of videos they can watch. It doesn't prohibit them from enjoying erotic dancing. It does prevent the conditions, the back rooms, the licensed prostitutes acting as strippers or whatever, that give rise to the negative secondary effects that the courts say that you can target and you can prevent. On the next slide, it also lays out several of the cases that uphold basically the rules like those that are found in the ordinance here. The alcohol ban, I argued the Daytona Grand case in 2007, but it was one of 5 cases over the last 5 years that uphold the same type of restriction on alcohol on the premises of sexually oriented businesses. On the next slide, you see some authority from the U.S. Supreme Court. Both this case, the New York State Liquor Authority case, it says, look, common sense, if you separate these two, that's a common sense approach to regulation. And the next case sort of follows up with that with a very recent case from Fulton County, Georgia, where the U.S. Court of Appeals for the United Circuit said, look, the strip clubs that have alcohol, they play a prominent and welcome role in the neighborhood as far as secondary effects. It was reasonable for the county to rely on this type of information to pass its regulation, which the court said was constitutional. Thank you, Scott. On the next one, we've got similar evidence from the Daytona Grand case, where the court said, the plaintiffs brought in their experts, they did their study, they spent a bunch of money, and basically it doesn't undermine the idea that failure to eliminate alcohol and sexually oriented business gives rise to lewd conduct, prostitution, and all this type of documented behavior between employees and patrons that also threaten public health and safety. And then on the next slide,